This is breaking news on CBSN Minnesota.
Used automobiles in a dangerous and fatal manner. We charge Christopher Dwight Rice with second-degree intentional murder, with second-degree unintentional murder, and criminal vehicular homicide for his actions in Brooklyn Park, killing an individual on a street there. In a similar fashion, because it was a similarly serious case, we charge Nicholas David Kraus of a count of second-degree intentional, second-degree unintentional, or excuse me, a charge of assault in the second degree with a dangerous weapon, and assault, a second count of assault in a dangerous weapon for driving his car in a fatal manner in Uptown. You all have received the information, I believe, and that's the preliminaries, and I'll be glad to answer your questions.
So, Mr. Freeman, Kraus is charged with second-degree intentional murder. What was the evidence of intent to commit murder?
Kraus, as you may recall from reading the complaint, he was at least partially drunk. He drove up to the barricades on Lake Street. He decided that he was going to go over them and accelerated rather than braked, almost like a Duke of Hazzard's driving stunt. He hit a car. The car hit a woman who killed her and injured another individual. He was interviewed the next day after being given his Miranda warning and acknowledged that he saw the barricade, knew it was a car, decided he wanted to go over it or through it, accelerated, knew there were people there, accepted the risk of what it might happen to people, and he thought he hit someone. Now let me just add, fatalities caused by cars and drivers are normally charged with criminal vehicular homicide. The problem with that statute is it's a 48-month maximum sentence. The conduct of these two individuals are so serious, in my view, they warranted a second-degree intentional charge. Is it an aggressive charge? Yes, it is. But we think we need to make a statement that this kind of conduct is simply not acceptable, and we're going to use the power of this office to try to say that.
Was there any evidence that he wanted to hit protesters in particular?
No, not so far. And he had as I said, a post-Miranda discussion the next morning. He's now in custody. I'm not certain once he gets lawyered up we'll be able to talk to him again. But there was no indication from that. No one on the scene heard him say anything. There's some evidence that people at the scene heard him say, "I'm sorry I did that." But, you know, when you had a chance to sober up and you have your Miranda warning, you got to know it's pretty serious. And he said the things that are set forth in the complaint.
I just want to follow up. So just to be clear for all those folks that say that this was an intentional targeted attack, no evidence to support that this was a premeditated, targeted type behavior.
Not at this time. Obviously, you know, the investigation's ongoing, that the police did talk to some individuals at the scene, but there's no one heard him say anything about it. We don't have any evidence that he told anyone beforehand, "I'm going to Lake Street, I want to run over protesters." None of that so far, but we may discover more, and if we do, we'll use it.
Can you tell us about his level of intoxication? Was it drugs, was it alcohol, or BAC?
We know for certain that it was alcohol. It may have been other things. His blood was taken at the hospital. Sometimes, if necessary for charging, we get the analysis immediately. It's still ongoing. We don't have that. It's real clear that Kraus had a profound drinking problem. It's been reported that he's already got 5 DWIs. He couldn't buy the car himself. He had to have a straw buyer, which is intriguing to me that I'm still looking at. And people said when he got out of the car after the crash, he was kind of stumbling around. But we don't have the data that we will have at time of trial.
Any indication of speed?
No, nothing is specific, and it's an older model car, so it doesn't have all the fancy technology in cars that you drive. But none of that diminishes the seriousness of what happened.
gears to Christopher Rice for a second. Couple questions. First off, in your press release, it's not in the criminal complaint, but in your press release, you said that Rice had harassed Mr. Pfeiffer previously. Can you talk about what that harassment was?
Apparently, he had driven erratically in the neighborhood on previous occasions and may have swung over, sort of at the decedent, but didn't strike him. That's all we have so far. Okay.
Also, there are accusations that this may have been a hate crime. Have you seen, because Mr. Pfeiffer is a gay married man, is there any indication or do you have any evidence of such claim at all?
No. There was a mention kind of in passing by the victim's husband that he thought it may have been. But again, there's no hard evidence. We understand the concerns of the GLBTQ plus community. This office has been very open and aggressive in charging hate crimes. We don't have anything right now. And to be fair and candid, second-degree intentional murder is a more serious crime with a much longer penalty than any hate crime that the Minnesota legislature has put on the books heretofore.
Finally, the Rice story is one of mental illness. He's diagnosed schizophrenic with bipolar disorder. He said in the criminal complaint he was off his medication for more than a month. The police were at his house for a potential threat the day before. Do you know why he was not civilly committed before Saturday's incident?
He has been civilly committed before. He was charged with aggravated robbery, and prior to trial, his defense attorney successfully brought a Rule 20 motion saying that he was not competent to assist in his defense, which is happening more often these days. So because of that, he was removed from the criminal court and sent to the civil commitment court. They committed him. There's a whole series, a long history. But in essence, he was committed, spent time in a hospital, inpatient, was provisionally discharged, had some problems, was called back in, was again provisionally discharged. This is a very familiar pattern with people who suffer from different levels of mental illness. Many, many times, and I am not a doctor, many times people can be really fine and functioning well with certain medications. Lots of folks don't like the medications, bad side effects. So they take the medications for a while, they're feeling good, they quit taking them, and the bad behavior returns. It appears that he was in one of those cycles when he was out.
What do you think his documented mental illness will play into the court process with these charges?
I would anticipate, defense attorneys being good lawyers, they're going to raise Rule 20 issues again, that he shouldn't be held responsible for his criminal activities. But let me just finish the point. It is rare that we charge second-degree intentional murder for reasons I said before. But particularly in this case, this will mean he'll be held on $1 million bail, and he will not easily get out this time prior to that successful, or unless the defense attorney is successful in the mental illness defense again. We need to protect society for as long as we can. And, we're not picking on a guy who's got mental illness. He did the actions that we charged him with, otherwise we wouldn't have charged him. And we have a responsibility to charge that. His lawyer and the court can decide whether or not he's mentally ill. And the court can decide to give him a different sentence because he's mentally ill. But my job, I think, is to prosecute people who do criminal acts, particularly really severely violent ones, and do what I can to protect society. So that's why I've taken the somewhat unique step of charging murder to intentional, which I have not done very often in the past.
So one more question on the Kraus case. He's not charged with criminal vehicular homicide. He's not charged with murder in the third degree, which we've learned a lot about in the last year or so. Is there a risk that he's overcharged at second degree murder? Will it be hard to prove intent? He didn't say that he intentionally killed a protester.
Well, he said he saw the cars and the barricades and the people. And at that point in time, he intentionally accelerated and went right at them. So those actions are strong evidence of intent. He said afterwards that he might have hit a person or two while he was driving his vehicle. You know, we think that's pretty good evidence of that. We always retain the right to amend our complaints as we move forward. You can do that even as late as in trial, when the evidence that is submitted would support a different charge. This doesn't fit neatly or comfortably in third-degree murder. And as you know, this office has not been shy about charging third-degree murder. In fact, I think we have more third-degree murder in other than drug cases than any other office in the state. But we felt second-degree intentional fit, and we'll see what happens.
Let me ask you, you sort of touched on this. Protesters have seized upon what they believe is a comparison to the Charlottesville incident where a right-wing person drove into the protesters. The motive in this case, or the motive that's out there in terms of rumors and innuendo, is really fueling a cycle of intense, even violent protests and clashes with police. Did this guy have any link to any kind of white supremacist groups or pro-police groups? And if you can kind of address that, I know you already have, but this has carried a lot of weight over the past couple of days. And a lot of actions have happened because people wrongly believe this.
This incident happened on June 13th. Correct me, today is June 16th. That's 3 days. We've collected the necessary information to charge this man with a very serious crime. We put him in jail at $1 million bail. It will be a long time. I would be shocked if he could make that. And we didn't do that by accident. We don't know more, Esme, frankly. We just don't know more right at the time. But it could just as well be that the alcohol in his brain and in his past caused him to do silly and stupid things. And it is a problem for us in law enforcement and prosecution about all the rumors and all the innuendos and all the conclusions drawn without evidence. This office is honor-bound to act only with evidence that we have before us. We can't make suppositions. We can't make things up. We can't think about maybe this or maybe that. That just isn't our job. That's wrong. If I charge somebody, I think they did it, but I don't have the evidence, that's wrong, and I ought to be kicked out of here. And we don't do that. So there's no indication today. I understand why those people feel that way. They have also been after me sometimes to charge cases when there simply wasn't the evidence to do that. And frankly, I had the courage not to charge them. And they still don't like me. But I can only charge things that I have hardcore evidence before me. And I don't have it of that sort.
Do you have any evidence at all?
No. One more.
Do you have video evidence of the collision? On the street? Or?
Good question. I wish I had. It's limited video evidence. It's mostly after the scene, okay? But it's more video evidence than we have in the Marshall shooting because the U.S. Marshals won't let us use body worns. But that's a topic for another day. Any last shot? Esme, you got anything more? Only one or two questions is a little surprising from the dean of our TV folks. All right, thank you.